You are on.
All right. Thank you. According to the clock on the wall, it is 5 p.m. It's February 28th, 2018, and this is the City of Green Bay Ethics Board. We are meeting as a continuation of a prior meeting that was held on February 21st. I think you all have a copy of the agenda in front of you. The first item is a call to order, and we've got roll call here. So just for the record, state your name for the roll call so we can get that in the record.
All right. Cordero Barkley. Mark Olson.
Bill Vandecastle.
Patty Kiewis.
All right. We have 4 members of the board present, which constitutes a quorum. Again, you all have the agenda in front of you. Is there a motion to approve the agenda?
Motion to approve.
Is there a second?
Second.
Okay. Are any discussion, any additions or modifications to the agenda? Otherwise, hearing none, all in favor of approving the agenda signify by saying aye. Aye. Any opposed? Motion carries. All right, item number 3, we are here for a hearing on the Code of Conduct complaint that was filed by Alderman Dorff against Alderman Zima. That was filed on January 18th of 2018 as a Code of Conduct violation. And as we are aware, but just for the record, this board has authority under the Code of Ordinances for the city to hear both ethics-related matters and matters that come up under the Code of Conduct. And this is specifically a Code of Conduct matter. So we will be bound by and proceeding under the rules provided to us by the City Council under that Code of Conduct. Let me state again for the record that it is the goal of the Ethics Board to provide and conduct a hearing that is fair, both in form and in substance, and that is our goal and our objective with these proceedings. I would note for the record that it is 5:02. Alderman Dorff is here. There has not been an appearance yet by Alderman Zima. Mr. Calney, again for the record, Attorney James Calney is appearing representing, as appointed by the city, to represent the Ethics Committee during these proceedings. Mr. Calney, what are our procedures in the absence of the party complained of in these proceedings?
The Code of Conduct specifically states that if a person who is the object of a complaint elects not to appear, that the board can continue, the Ethics Board can continue and hear the evidence presented. That being said, I do want to address a couple other issues of concern. First of which is that also pursuant to the Code of Conduct, a subpoena is to be issued directing the appearance of the person that's named in the complaint, in this case, Mr. Zima. Mr. Zima was served for our last meeting, but not served for this meeting. I know that we did send an email to him informing him of this meeting, and I understand the clerk had called him. So I have reason to believe he has been noticed. However, there has not been personal contact.
Okay.
And that could cause a problem with our procedure.
All right. And sorry.
Sir?
Thank you. We have in the record a number of documents that have been submitted along with Alder Dorff's complaint. One of those documents was a request by Alderman Zima for an adjournment. So that is another issue that needs to be addressed.
And there is also the issue of, we haven't addressed the conflicts, the remaining conflicts in the board.
Right.
And of course, the board hasn't addressed Mr. Zima's objection to my participation.
All right. Well, let's at least proceed with what we can at this point. Again, from a carryover from the last meeting, we did a conflicts request to all the board members. Everyone except Mr. Olson, who couldn't be with us that night, has addressed that. Mark, I asked the other board members if they felt they had any conflicts or conflict of interest in continuing to pursue this or to sit on the board. And as I think you probably are aware, we had two members that feel they had a conflict at the last meeting, and that led to the adjournment. I would ask you the same question. Do you feel you have any conflict or conflict of interest in moving this matter forward?
No, I have no conflict.
Okay. At the last meeting, we started to get into the issue of Mr. Zimma's concerns with respect to Attorney Calney. I believe that those were addressed. Mr. Calney, am I clear on that? Has that been addressed, or where's the status of that at this point?
Well, the board didn't consider it directly. Basically, Mr. Zimma and I had a disagreement about a policy issue about 10 years ago, and Mr. Zimma has stated that we have personal differences. He's not here to state his side, but from my standpoint, the standard for my participation is pretty low as far as, or high depending on how you want to look at it. The way the law reads is for personal abuse or criticism to be considered a impediment to somebody participating as an adjudicator in a matter such as this. That creates a constitutionally impermissible appearance of bias only when the adjudicator has become embroiled in a running controversy in which the litigant has slandered the adjudicator in such a manner that it's unlikely for the adjudicator to maintain a calm detachment. Frankly, as I mentioned last week, I was not aware that Mr. Zimma would even object to my participation. If Mr. Zimma slandered me, very frankly, I've had a pretty good career, and I really wasn't impacted by it, and nor aware of it. I really carry no grudge here. I realize I may have lost some business, but believe me, that wouldn't be the first time. So from my standpoint, I feel that I can participate. My role is very limited. My role would only be to see to it that due process is addressed and to guide the board in that regard. That being said, Mr. Zimma has raised an objection. Apparently, he doesn't want me to be involved in this. If the board sees that as a taint, I certainly will listen to what the board has to say and not participate, but that's up to the board.
I guess I would state for the record, from my perspective, I've known Attorney Calney for probably close to 40 years now professionally. I have no reason to doubt his ability to be impartial and to provide sound legal advice to the board in a fair and impartial manner. And from a procedural standpoint, Attorney Calney wouldn't be involved in weighing any of the evidence that comes before us. He wouldn't be involved in the deliberations other than to be in the room to provide legal counsel in that regard. He obviously wouldn't be voting on any decision that we would make. Again, his involvement would only be on the legal and procedural side of this. So I have no reason to request that Attorney Calney step down, but that's my position. If there's anybody on the board who thinks otherwise, I guess I would entertain a motion that would address that. But if not, I think we continue as we have started. Anybody on the board have a desire to seek other legal counsel?
No, I think we should proceed as we are currently seated and move forward.
All right, hearing no motion from anybody to change course at this point, we will proceed as scheduled. Ms. Dorff, I asked this at the last time, but I will repeat my question. Any concerns on your part for any of the current members of the board in proceeding? Any concerns you have regarding a conflict or a conflict of interest?
No, I have no concerns. Thank you.
And Mr. Zimma's absence, we won't be able to ask him that question. The other thing that we need to address is as to whether any of the members of the board have received any ex parte communications from any party involved in this. If you have, let us know so that we can address that. Anybody on the board received any communications from either Ms. Dorff or Mr. Zima? I would note for the record, as chair, I did receive a copy of Mr. Zima's letter that you all received. It was addressed to me as chair. Also received a copy of the letter from Ms. Dorff in response to to Mr. Zima's letter requesting an adjournment. But again, those have all been shared with the board. So I would also join in the fact that I have had no communications other than those two letters from any of the parties here. So that would not be, I think, an issue that would need to be addressed. So the question before us then is, do we proceed tonight in the absence of the respondent, Mr. Zima? And I believe that's something that we should address as a board, obviously. Any thoughts from anybody on the board as to how you'd like to proceed? Or any questions for Mr. Calney about the process in the absence of Mr. Zima?
What does the board here have for options regarding the fact that defendant is not here?
Question.
Well,
Oh.
there we
Oh,
are.
there he is.
Yep. I have lost my own keys many times. I would know for the record that anywhere you'd like, that Alderman Zima has arrived, and so we will give him a moment to get himself situated here. Mr. Zima, we've just gone through sort of a recitation of where we were from the last meeting. And Mr. Olson, who was not at the last meeting, addressed his thought that he did not have any conflict with proceeding with today's hearing, either from an interest or conflict of interest. And I had just finished asking Ms. Dorff if she had any objection to any of the current board members continuing on with these proceedings. Now that you're here, I would ask you the same question, now that we have Mr. Olson and we do have a full board. Any concerns on your part or objections to the current members of the board proceeding further? You are now.
Okay, I guess to start with, if there were a real hearing, I would probably ask for a change of venue, as all of you were directly appointed by the mayor, and the mayor, in my belief, has been the driving force in fomenting this complaint so ably by his chief supporter, one of his chief supporters, Barb Dorff. So, I mean, I'm standing before you folks who have all been appointed by the mayor, who has a very big interest, and records will show what an interest he played in was the driving force here. So I feel all of you are really somewhat disqualified. I think
On what basis?
the fact that you're all appointed by someone who has a very big interest in this, and I'm not saying any of you would be dishonest, far from the contrary.
Well, I hope you're gonna show that evidence, because I take that very personally. So if you feel we're not qualified, well, I take it personally.
This would just be standard procedure, that people would recuse themselves when they have a connection with somebody involved in the case.
That's up to the individual whether they.
I think it probably should be another ethics committee from somewhere else.
Let me just,
You asked me if I had any objections.
I understand. Okay.
Should be noted on the record.
And I have an objection that you're continuing with Mr. Kelly here. I made it very clear there was a tremendous conflict of interest between Mr. Kelly and myself. I was primarily one of the primary responsible for his removal from being an attorney for Brown County at the time. And he left without all that he had asked for in his payments. I do not feel he can be impartial in making rulings, and rulings can affect, what you folks make judgment about.
He's not making rulings, he might provide advice.
Advice, rulings, whatever you want to call it. I'm on record, I'm opposed to this. I'm holding my rights. I don't know what he's doing here. He knows very, very succinctly the differences we've had. And of course, I take great umbrage with the fact that Ms. Dorff, who couldn't even file her complaint correctly, it was given to the clerk's office, and then the clerk, through the attorney's office, hires Mr. Kelney to look over her complaint and give her directions of what needed to be done. Wrong, very wrong. If she wants to have a proper complaint, she should have hired her own attorney or sought her own advice, not depended on the city of Green Bay. What did we pay? $1,000 for Mr. Kelney to look over the report and point out her deficiencies? I think that's all wrong.
Well, let me.
So anyway, I'm on record,
Okay.
Right, right. If I may address that.
and you can address it all you want. I'm just telling you, I'm opposed to it.
I understand. Let me respond on behalf of the board. You are correct that every one of the members of this board was appointed by the mayor. But what you failed to indicate is that although the mayor appoints, it's up to the city council to approve us. So if the city council did not approve us, we wouldn't be sitting here. So you and Ms. Dorff and the rest of the members of the city council approved all of us to be here. So it's not just an issue with the mayor. We are here because the city council put us here.
You know that that's a formality.
I,
In all my 42 years, I've only seen one or two volunteers challenged.
well,
Very,
all
very,
I'm
very
saying-
rare event.
All right.
That's perfunctory.
You made your point. All I'm saying is that we were appointed by the mayor, as you noted, but we were approved, and we're sitting here because we were appointed by the council. If we were not appointed by the council, none of us would be here. Secondly, with respect to the issue of Mr. Kelney, I would state that unfortunately, before you got here, we addressed that issue. It was voted on by the board that the board did not have an objection to Mr. Kelney continuing in his position. Thirdly, in terms of the complaint, I think I'll let Mr. Kelney address the complaint, but I would note that to my knowledge, almost every complaint that has come before this board, the process requires for all those complaints, it goes to the clerk has to review it, and then there may be additions or modifications to that complaint for sufficiency purposes. My understanding that several of the complaints that have come before this board before have gone through that same process. They've been refined, revised, and refiled. So the fact that Ms. Dorff refiled her complaint is nothing out of the ordinary for the proceedings before this committee.
Sorry, I didn't hear that.
I'm sorry, we have to speak up because we do have a court reporter. I'm sorry. Your question again, sir?
I said, who aided the people in those cases?
I can address that. The city,
you
the
weren't
city
even
attorney-
here.
The city attorney addressed them, and I know that because I personally contacted Mr. Joe Falls and talked to him about what the procedures is. It was my intent to follow the procedures in regard to interpreting the code of conduct and their procedures as closely as possible to the way it's been done in the past. And in fact, I used many of their forms in regard to the response. Also, I want to make it very clear that transparency is going to be very important as long as I'm involved in advising here. All correspondence that I'm aware of that occurred between Ms. Dwarf and I, you'll have a copy of, and you'll be able to look it over and see if there's a problem. Also, Mr. Chairman, I'd remind you, we should probably go through that record too pretty soon.
Yes.
I can just respond to Mr. Kelney. I have no problem with outside attorney being here. In fact, I think it's proper. I object to you being the person here.
I recognize that.
And I think the city was very incorrect in the previous hearings, having the city attorney, advising about people they're supposed to be defending. The city council is under the guidance of the city attorney, and city attorney should never be involved in anything that, such as a code of conduct hearing before the Ethics Committee. So I'm putting that on the record. I think that was wrong before. I don't think it's wrong that you're here. It's just that I object to you being the one who's here because of our past conflicts. So I just want to make that clear.
Understood, and it is a part of the record as we proceed. Mr. Kelly, you raised the issue of the materials that have been submitted so far in the record. Is that contained in this document?
Yes, it is.
All right. So, just for the record, to indicate what we've got in the record, and this will be made available as soon as we go through it here. We've got, and again, correct me if I'm wrong, the first thing we have is the Code of Conduct complaint. Then there is, that was the one that was submitted on December 10, 2018. The second item is a letter of deficiency from the city clerk dated January 15th, 2018. Then there is a revised Code of Conduct complaint that is dated January 18th.
Mr. Chairman, there are some emails regarding the deficiencies that are also included.
All right. We have emails regarding the deficiencies. We then have the complaint that's before us tonight from January 18th of 2018. We have a summons issued by the city clerk dated February 4, 2018. There's an affidavit of service of the Code of Conduct that the complaint was served on Alderman Zima. There is a letter from myself as chair to Ms. Dorff and Mr. Zima regarding the procedures to be followed during the hearing and prior to the hearing. There is an email from Ms. Dorff from February 15th of 2018 requesting that the hearing be removed or moved, to room 604. There is a letter from Mr. Zima. It was received by the clerk's office on February 16th requesting an adjournment of the hearing. We also have a letter from Ms. Dorff dated February 23rd, 2018, with objections raised to Mr. Zima's letter of February 2016, 2018.
If I may, Mr. Chairman, there are also some additional emails that are included. Another one dated February 17 regarding the moving of the meeting. Another one dated February 19 regarding the Code of Conduct complaint generally. Another dated February 24th regarding the objection. It's basically the email that included the objections. An email of February 26th, I believe it's from you, transmitting the objection to the parties, and an email regarding the receipt of the objections when it was received. So that should complete the record. Those are the documents that we know of that are in file.
Okay. Are there any objections to the admission of any of these documents to the record as they have been received through the clerk's office? So again, any objections from any of the board members to the receipt of these in the record? And from any of the parties, any objection to these being in the record?
Are you talking about the whole complaint?
Well, yeah, this packet of the complaints, everything that has passed through the clerk's office and gotten to the board members and the parties.
Yes, I have a serious objections to anything except the complaint itself. She's ingratuitously just added public request records that are not anywhere dealt with in the complaint. Maybe some are a little bit, but they're in the complaint itself. Nothing outside of the complaint should be considered part of the complaint.
We're not,
And I'm insisting on that.
they are not considered part of the complaint. They are part of the record of the proceedings that have come before.
They are
So
not for your consideration. All that's in front of you is the complaint that you have.
So are you trying to tell us that we should not consider your request to adjourn? Are you telling us we should not consider your request to adjourn? It sounds like you just said that we should only consider what's in the complaint.
Whatever the complaint is the complaint is.
Unquestionably. And all I'm saying is we're making a record here as to what has come into the clerk's office regarding these proceedings. We're not making any rulings on the validity of any of those things, just a note for the record to make sure we have a full record of what's here in these proceedings. We won't be considering those things that are outside of the complaint in terms of the final decision here.
Those are not sworn complaints. They are nothing more than hearsay, and they should
I-
not be considered by this board. I want to put that on the record. That is my objection.
All right, objection duly noted. Are there any other documents, before we begin, any other documents that any of the parties think that have been submitted that are not part of the record so far?
I've just handed this. I don't know if I have all these or not. Is that how we do things? Just
Yes.
hand somebody something and ask if it's okay?
I'm asking
Is
you,
that justice?
I'm asking you if there's anything else
I
besides
haven't had
what
time
we-
to read the whole thing. You just handed it to me.
All right. I haven't
So
heard
I
any-
guess I'd have to put that aside.
Okay, your objection is noted, and we will move forward. Next item on the agenda are some preliminary matters. We've covered the conflicts issue. We've reviewed the procedures and the record so far. The other item that is before us, before we begin with testimony, is Mr. Zimma's request to adjourn. That is part of the packet of documents that we have before us. Mr. Zimma, is there anything that you would like to add to that request for an adjournment before we take it up for consideration?
No, these are my objections, yes.
Okay.
And these are my requests. And if you want to take them one at a time, I have no problem with that.
Well, we've got the document. That's your letter of, let me get it here. That's your letter of February 16th. That's correct. Okay. Anything more that you want to tell us about any of these that we should consider? Okay.
Mr. Chairman, in the interest of making a full record, addressing each of the items is probably well advised.
All right, so let me just clarify. I would note also for the record that we received some objections from Alder Dorf to that letter, or the issues that were brought up in that request. Mr. Kelly, from a procedural standpoint, should we address Mr. Zimma's request first and then take up Ms. Dorf's objections?
That makes sense, to do it in that order, and then have some discussion after. There'll probably be questions from board members.
Okay. All right, so let me get my notes here, get the right page. Mr. Zimma, you indicated that you needed in your request that you needed more time to prepare. What were your concerns in that regard?
I'm responding to your letter to me, Mr. Chairman, in which you say that I have a right to have representation, to cross-examine witnesses, et cetera.
Yes.
And I have made attempts to, and I have secured at least one attorney, but I have talked to two attorneys. And the attorney that I have engaged to help me is at this moment on a trip out of the country. Will not be returning to the Green Bay area till the 14th or 15th of March.
Can you state the attorney's name?
Certainly I can. Janet Angus.
Janet Angus.
Yes, that's correct.
And I have approached a second attorney in Madison, and his calendar was absolutely unavailable for the 21st, and I think he'd be requesting some period of time to review the complaint and have a chance for taking a deposition or two or whatever he wants to do. I don't tell him what to do. And he is not available at this point in time, but I'm very much admirer of him. I feel very satisfied with him, and he is willing to work with Janet Angus also. So, but my one closest to home is not in the country, and the other is not available.
All right.
And for the record, the name of the attorney in Madison, please.
I will remain with myself for the time being.
All right, any other questions from the board at this point? Secondly, Mr. Zimmer, you indicated that you had some public records requests to the city that were still pending. This, again, going back to your letter from a couple of weeks ago, the 16th of February.
Well, do you want to start with number one, or why don't we
Okay.
take them in order, or whatever?
All right, well, your item number one was that you needed some more time to prepare.
Yeah, so let's address that.
Well, what's your concerns?
My concerns is that I personally need more time, as
Why?
well as an attorney,
Why do you need more time?
because it's voluminous.
Well,
There's hours and hours and hours. And of course, Ms. Dorff has just taken words and phrases from here, there, everywhere. All this has to be put in context of the entire meetings. This is a very large group of complaints here. Way more than anything you've received up till now.
that is true. However, again, as you're aware,
I was
we-
only served these papers on the 6th of February.
True, but you were aware that this was coming back in January.
Doesn't mean anything till you're served.
But you were aware that
Yes.
that this was pending.
And I started, I did start my search before February 6th, but not too long before that.
All right.
I think it's a reasonable request just on its face. This would be routine anywhere else. But of course, I think Ms. Dorff, well, she says that I want to hold it past election. Maybe she wants to push it before the election.
Well,
You know, I mean, it's tit or tat.
all right.
And I actually have no objection to any of the words she says I used. But that's later on here.
Again, we've already addressed the issue of the attorneys. Your third point was, we will get to that. We're just trying to fill in the information here so we can address these.
From us telling them the procedures.
Yes,
And then discuss it amongst yourselves.
that is correct.
Okay, thank you.
We've addressed the point about your attorneys. You also made a request in number 3. They had a conflict with a county board meeting? Correct. Well,
You need to schedule these on a meeting on a day when other public officials are not in meetings.
my experience with public officials is that they have meetings almost every night.
Well, I'm here to
Your
tell you
four-
that Thursdays are very free for most people.
You've requested,
Fridays.
your item number 4, you indicated that you had made some requests to the city, or to the city for records from the city, public records request. Have you received those records that you requested?
I had only a response I made 2 separate requests. I have only received response to one, and then I have re-requested, and I have not heard anything on my second request yet.
What were the dates of the request, please?
The one that I haven't received a response to is February 8th. Excuse me, I have to correct myself a little bit there. I did receive a response, and they asked me to amend my request because they thought one of the 4 points that I had requested was too voluminous and would take too much time. And so I redacted, I removed number 4. I had 4 requests. I removed the 4th one at their request so as not to burden them, but I have not received answer on the other 3.
All right. Your 5th issue was the right of representation. You brought up the issue of obtaining a list of the witnesses that Alder Dorf was proposing to call. I understand that we're here under a quasi-judicial proceeding, but we're also, this is somewhat of a special proceeding since we're operating specifically under the rules of the Code of Conduct that the City Council has provided us. You've indicated that you would like to potentially depose those witnesses and you'd like a list of them. Can you tell us from the Code of Conduct what authority you think that we as a board have to compel disclosure of witnesses?
Well,
What does it say that in the Code of
you
Conduct?
know, one of the assistant city's attorneys who is now the human resource director advised Mr. Schmidt, who has been the driving force in all this, he advised him that complaints, the addendums that Ms. Dorf has attached, they would have to be witnesses in order to consider what has been ingratuitously attached to the complaint. And so, I mean, people have to make a complaint. And my understanding, I've been told by people from both departments that are in question, that no one from their department, that's from them personally, that they never made complaints, that they were sought after.
Okay, that, what you're doing is getting into the evidence here, and you'll have your turn for
Well-
that. I'm simply asking, you requested the right to call and cross-examine witnesses, which is provided, but you've also asked for us to provide you with a list of the witnesses Ms. Dorf intends to call.
Well, I just assume that there's some due process in things. Do we just run a star chamber operation where we just bring people up and third parties can talk about hearsay things?
No, that's part of the proceedings, but this is
Well, I'm not going to allow any hearsay.
Neither am I. But what I'm asking you is, what authority do you believe that we have as a board to compel someone to disclose witnesses prior to the hearing?
Simple justice.
Okay. But do you have anything in the code that provides us with that authority?
The code is so inadequate, it's pathetic. It's a pathetic code.
That wasn't the question.
That wasn't the.
I'm telling you, it's inadequate. It doesn't follow any rule of law.
All right.
Excuse me, but we're asking for a specific example, and we're not getting a response to that question.
Mr. Van Kessel.
Yeah.
I do want to point out that it does state that attached to the complaint, the code specifically says attached to the complaint, the person making the complaint shall provide all documents or other materials in the complainant's possession that are relevant to the allegation, a list of materials relevant to the allegation that are available but not in the complainant's possession, and a list of documents or other materials relevant to the allegation, but unavailable to the complainant, including the location of documents if known, and a list of witnesses, what they may know, and the information to contact those witnesses. So there is a reference that the materials attached should reference the witnesses called. That being said, the way the complaint is written depending on what elements Ms. Dorf is deciding on proving, a lot of the evidence would be a self-authenticating public record. I don't know how many witnesses she'd have to call, frankly, but that's up to her and how she does it.
I was
Okay.
asked to limit my request for open records, then maybe she's got to limit her complaints against me. I fully admit to everything she says I said, no problem.
All right. The other issue then would be the right to depose, and again, I would question whether we have the authority to compel anybody to appear for a deposition prior to the hearing.
This is a quasi-judicial hearing similar to a Police and Fire Commission hearing or a hearing before the Protection and Welfare Committee. There's no clear right spelled out here for deposition, and I don't think we would have the authority to compel it.
In other words, you can just run wild over.
No, we're not going to
With
be running
hearsay
wild.
evidence.
We are not going to be running wild. All right, the other, item number 6, in your letter was a request for written and audio copies of the complaints, complete with the exact minutes and seconds where the allegations can be found. I don't know that we necessarily have the authority to compel that, but Mr. Kelly, what, am I missing something? there?
It's notice pleading, and it has to give Mr. Zimmer an understanding of what was, what occurred and when it occurred. But as far as the right to discovery, again, this is a quasi-judicial hearing. It doesn't reach the level of a civil trial. Also, I'm not sure a written list of exactly what was said would be disclosed even in regular discovery in a civil matter. That being said, we want to make sure we're on the same page. I think making sure that we all are looking at the same meetings and we all have copies of all that makes sense. I think pointing to specifically what time there was a problem, I think that's a problem too. Context might be important. What happened right before that could be important. So I think it's important that we all know what meetings we're talking about. We're all looking at those, the same meetings, probably have on a drive that we can look at. But I don't know that I don't think a written synopsis or a written transcript of exactly what was said is something that we're in a position to order to begin with, and probably wouldn't be required even in a civil case.
Looking at item number 7 on Mr. Zimmer's letter is that, you'll get a chance here in a moment. All right, what's your reply?
Mr. Chairman, all due respect, I filed, along with 4 other aldermen, a complaint over at the district attorney's office regarding our city attorney and our mayor, Jim Schmidt.
What relevance is that to these
You'll
proceedings?
you'll find the relevance. When I talked about what went on at a meeting and the words that I used with the mayor, I said the meeting date, the minute, and the second where he could go to find what I was telling him. And do you think that do you think he would respect me if I just said, oh, you can find it in the meeting that went on for 3 hours? No, of course not. So I'm just telling you, where is it so that a person can access it a little more easily and analyze it a little more easily?
So noted. Thank you. So item number 7, you requested the right to reserve the right to offer additional objections to the process and the content after you've had an opportunity to retain counsel. I think that's appropriate leading up to the proceedings. I don't have any, I don't know if any board members have any comment on that. And you are also requesting 60 to 90 days to retain counsel, investigate the claims, and prepare your defense. Anything else you want to add to that? Yes.
I think that's a very modest request. After all, I know when I made some charges 3 years ago, it was a year and a half before the charges were brought forward based on a complaint. People need time to investigate. This is a very voluminous, very accusative. I've been in office 42 years. I have never been questioned about things that I've said until Ms. Dorff, who's been in office for 2 years now.
Thank you. Ms. Dorff, I'd like to give you an opportunity to respond. I know that you sent in a letter addressed to me that's in the board's packet, and I believe it's been provided to everyone with some concerns about Mr. Zimmer's February 16th letter. Can you address those to the board, please?
Certainly, thank you. Can I assume that you've read them, that I don't need to go through and read them all?
I believe we have, yes.
Okay. So as far as the objection to number one, I have no objection to Alder Zima needing further time to hire an attorney. If he needs that further time, that's fine. I will address the amount of time I think is appropriate a little later on in his later objections. Number two, I was questioning whether he indeed had spoken with an attorney. He has put that to rest for me. He managed to come up with the name of Janet Angus, and then, not the name, but a description of an attorney in Madison. So I find that to be believable, that he did indeed try to find an attorney. 3 is no longer relevant. It's past that date. 4, I would just reiterate that I know what the records request was regarding the emails, and I also know that there is not going to be any relevant information in those, but he needs to see that for himself.
Okay.
So I respect that. 5 is again being represented by counsel and deposing witnesses. Well, let me just put Alder Zima's mind at rest. That I will not be calling any human witnesses. My entire evidence will consist of the video of Alder Zima making comments that I believe violate the code of conduct. So there will be no human witnesses called. It'll just be the authenticated video. 6, I am under no obligation to provide my work product to Alder Zima. I will not be providing that video before we have the actual testimony. I have provided exact dates, and I provided exact phrases, and I needed to spend hours looking through each and every one of those meetings in order to decide whether or not I had a valid complaint. And I did all that between December and January before I filed the complaint. And then I was further asked, when I just had in general what the meetings were and what the phrases were, then I had to go ahead and revise that entire complaint again and make it even more specific. It will be very easy for Alder Zima to simply go to his computer, pull up the videos of our council meetings and protection and welfare meetings, and I limited it to those 2 types of meetings. He knows the dates, and he can find everything he needs to find. It's already in the complaint. It's all there written out for him. I'm sorry, it's my turn to speak, Alder Zima. Number 7, yes, I would also like to reserve the right to offer additional objections, and I think that's reasonable that he also does that. I feel a period of 60 to 90 days is a little lengthy. I would say that it says right in the process, in the portion where you file the complaint, that you have 45 days from the time which the complaint is filed. Well, we've gone past that already. So I think it would be reasonable to say within 45 days of the first time he was served. But again, I leave that up to the Board of Ethics. Do what you feel is best in this case. Do what you feel will provide for a fair and just hearing. And I will be very supportive of whatever decision you make on that. And I think that's about all I have to say. Thank you.
Very good. Certainly. Floor is yours, Alder Zima.
First of all, it's not good enough that she says that the laboring order is on the back of the defendant to know what the charges are in full. It's up to the plaintiff to make it clear and not just some generalized, oh, it's in this meeting, go find it. Unreasonable. The defendant has to have a right to know exactly what they're talking about. Now, I guess I'd settle for at least, the times, and I don't know if they can provide the recording. I don't have access to something that can transcribe those words out to me. These words, as Mr. Kelly had said a little bit earlier, there's context to words, not just little phrases. They're part of larger conversations, part of larger debates. So I think it's incumbent to the plaintiff here to not just point out some word she doesn't like or some little phrase she doesn't like, but the whole context of what that is. So I would like that phrase in context delivered to me so I can examine exactly what she's talking about, not just a single word or a single little phrase. And as to her other objection about, well, we have to get this done in 45 days. It started within 45 days. There's nothing in the world that says this has to be completed in 45 days. It does not say that anywhere in the record. So this canard here that, we got to be fair to Mr. Zimmer, we got to get it done in 45 days. Well, I wasn't even served till the 6th of February.
That is true. That is true. All right, anything further from the parties? Yes, Ms. Dorr.
The thing I would like to say is that words simply would not do it justice. One needs to watch the videos, and I have provided context in each of the videos. And one can judge for oneself whether it's enough context. That's why it is essential that Alder Zima go back and view those meetings. He is the one talking. He is the one that was there, so he needs to know the context. Just giving written words, which frankly I don't have the written words, it's in a video, would certainly not be enough.
Okay. Any questions from the board? All right, Mr. Zimmer, just for some clarification here, I know we've got this issue about the 45 days, and you've sort of addressed this, but I just want to make sure that we understand that by your request for an adjournment and rescheduling of this, that any jurisdictional issues related to the 45 days, if we go beyond that, you're waiving that? Is that my understanding?
Well, it's not of course I would waive it. I don't know that I need to waive it. I think you started the process within 45 days, and whatever decisions you folks decide is fine, whether it took 1 month or 6 months. We want justice, don't we?
Absolutely, absolutely. Mr. Kelly, any thoughts from you before we proceed?
I understand Mr. Zimma's understanding of the ordinance, but some people can argue it differently. I'm understanding Mr. Zimma to tell us that any objection that he might have to competence simply is not going to be raised. And I think it's important that we have that understanding. That would be-
I absolutely do not hold the board responsible if this takes more than 45 days.
and
Why
you
would I?
won't-
I mean,
and- And you won't raise the issue of competence at any time in the hearings.
Competence?
Yeah, competence means the ability to go forward with the case.
Well, I think what I understand you're saying is that I think think I'm competent, don't you?
It's a jurisdictional issue, having to do with whether you can go forward with a particular matter.
Maybe if I can,
I don't have any problem.
if I can just shorten, if we go out, let's say we have a hearing in April, we want to make sure that nobody's going to come back and say, well, you can't have the hearing in April now because you didn't get it done within the 45 days provided by the code.
I waive any rights to that.
All right, all right. All right. Mr. Kelly, I note on the agenda we have the possibility of going into a closed session. What was that for?
If you want to discuss this adjournment in closed session, it would provide for that.
Okay. Any of the board members see a need to go into closed session to discuss this? I don't. No.
And it's best to stay out if you can avoid it.
Yes, absolutely. That's why I'm asking. That's why I'm asking.
Closed session.
Absolutely, I agree. I agree. We will be deliberating in closed session once this is finalized, but, right. All right. So we've heard the provisions, the responses from both parties with respect to adjournment. Is there a sense of the board whether we grant an adjournment and look for a new date for proceeding directly to the hearing? Is there a motion to that effect?
I would make a motion to that effect.
All right. So we have a motion, and your motion is to seek a new date for adjournment with the parties?
Correct.
Is there a second?
Second.
We have a motion and a second. Any further discussion or questions? Hearing none, all in favor signify by saying aye. Aye. Any opposed? Motion carries. Let's get out our calendars.
Right.
Mr. Zima, you indicated, and just clarify for me, you said your attorneys would not be available until the middle of March?
Not returning to the country till the middle of March.
Middle of March, okay. Ms. Dorf, any timeframe from your perspective on this? No, tomorrow would not be good, all right.
No, I don't, there's no time that I can.
So realistically, and anybody jump in and correct me if I'm going beyond this, but realistically, I think we're looking at probably sometime in the early to middle April for a hearing date. How does that fit with everybody's calendar? That your attorneys would be back by then?
There's more than just my attorneys, Mr. Chairman.
I
There's
understand.
myself.
Okay,
You know that I'm in the middle of an election.
I understand that.
I'm slandered regularly in the mail, I'm in the media, and I need all my time to do that. I have one preference. I wouldn't mind taking it to our present council to have it decided. But I also need more time to help my counsel when I do receive it. So I really feel middle April, beyond there, actually, probably end of April, first part of May, something like that.
45 days puts us about April 15th. So if you put another week on there, 10 days,
All right.
does it seem reasonable? 25th, somewhere in that range?
Time that we could adjust that. But I'm not interested in prolonging this into eternity.
Right.
I'm quite adamant in my defense. I'm anxious to conclude this hearing, but I want to do it in due process with all my rights and, protected.
I understand. I join you in the agreement that we want to get this done both fairly and properly, but as soon as possible. So again, looking at calendars, starting with the middle of April and pushing out a little bit from there. Looking at my calendar, the 15th of April is actually a Sunday. The next week, the week of the 23rd. Anybody have any issue with that week?
Just the 25th.
25th? Okay.
We just agree we'll schedule during the week of the 23rd, and everybody has to check their calendars and so forth.
Right.
But we would try to target that week.
If I might suggest, and, you know, after we've settled in with representation, that a date be set somewhere between those two dates.
Go ahead, Patty.
May seems to be getting long, is just my opinion. I don't know why we would push out that far. I think, I want to make sure that Alderman Zima has the time to prepare what he needs to, but honestly, we're in February. May's a long time. It's just my suggestion. I think April is adequate to look at the middle of April.
Right, I think I would agree also with the two of you that we look at that last week of April, and that we make an effort to look at someday, other noting that we're missing the 25th. Yes, Jim?
Is the last week of April a fifth week?
There is, April 30th is on a Monday.
It's a Monday. Well, that would be a week when there wouldn't be council meetings?
Correct.
So that, you know, if there's any question about Mr. Zimmer needing witnesses, doing it on that date actually makes some sense.
The
On the
30th?
30th?
Right, because nobody would be in meetings on that date.
30th.
And it, you know, just know that from experience. The fifth days of,
Problem with it. I just want to reserve my right to something between April 15th and May 15th, depending on what attorneys
Right.
can be
Well,
available.
let-
You know what attorney schedules are like.
Yes, I do. What I would propose then is that Ms. Dorf, we're jumping around here without consulting you on this as well. If the April 30th look okay for you?
It's fine. Yes,
Okay,
thank you.
so let's schedule it for April 30th. And then if your council has some reason to seek another adjournment, they can make that request at that point. Okay, so April 30th,
Is it still 5 o'clock?
5, does that 5 work for everybody? That's a Monday, yes, last day of the month.
I just have to check my schedule,
Okay,
but that's true of everybody.
right, right. Okay, so we'll set it for April 30th, 5 PM. All right, anything further before we look to adjournment? Attorney Kelly, any other procedural things we need to address?
we could address setting a time for there to be any issues raised regarding the hearing. The way we set it up last time, if there were objections to the proceedings or other concerns regarding the hearing, we gave the person until the Friday right before the hearing to do it. And we found out that doesn't work very well. It doesn't give us much time to react. Might make some sense to say that on or before the 15th of April, although that's tax time, sometime on or before a certain date, a set date, to give
Well,
people time that objections are filed.
What if we look at the 23rd, which would be the Monday before the hearing? The deadline of the 23rd to submit any issues?
Any objections or additional requests for additional information, whatever.
Okay.
Or maybe even have a conference at that time that you or I could take care of to make sure the evidence is going to go through smoothly, time out the hearing. That's commonly done, for example, in PFC hearings.
Okay.
Mondays are not good days for attorneys, are they, generally? I was thinking more like a Thursday there,
Well, but again, as Attorney Kelly mentioned.
Thursday before the
25th or
23rd.
26th.
Yeah, that was.
25th,
it-
26th.
It was pretty short the last time. I think we had the 16th, and the hearing was on the 21st, so it was kind of a last-minute thing that we addressed. So this kind of pushes it back a couple of days.
Maybe we should go that Thursday before the 23rd then. It gives us 10 days. And I think that's a reasonable time for the attorney to react in this.
That would
Well, that's
be,
shortening it up even more.
that would be the 19th.
You might as well just stick with your Monday then.
Right, so if there's any issues or concerns that need to be addressed prior to the April 30th hearing, those will be addressed on or before, by 5 PM on April 23rd. And again, those get filed through the clerk's office, and then that gets cycled around to everybody that's involved, so. All right, anything further before we adjourn? Hearing nothing, is there a motion to adjourn?
Motion to adjourn.
We have a motion, is there a second?
Second.
A motion and a second, all in favor signify by saying aye. Aye? Any opposed? Motion carries. Thank you all very much, and board members, thank you for your time.